It's 9 o'clock on Wednesday, March the 3rd. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Beck, Curcio, Farmer, Griffey, Hardaway, Howell, Lamberth, Moody, Russell, Chairman Doggett.
Present.
Mr. Chairman, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin this morning? I do have a visitor here from the district, Miss Emily Hamby, that's sitting in the audience today that is visiting with us. So if you would, please join me in welcoming her this morning. Moving right along, we are going to skip through our calendar. Members, we have many bills on the calendar this morning, but we're going to start out with item number 15 on your calendar. Number 15, House Bill 786 by Leader Lamberth. And if you would take your position there at the main podium. Do we have a motion or a second? Properly motioned and second. Leader Lamberth, if you recognize, there are two amendments. Do you wish to proceed looking at these amendments?
Yes, sir. Yes, sir.
Amendment number 003738.
Yes, sir, Mr. Chairman. And, Mr. Chairman, this bill is constitutional carry. It's what I began by describing last week. This expands freedom significantly in our state and makes it clear that if you're 21 years of age or older, or if you're 18, have been honorably discharged from the military, and you're lawfully in possession of a gun in a place where you're lawfully allowed to be, then there will be no criminal penalties against you. Again, lawful gun owners who are allowed to possess their gun in their home, their business, their car, their bicycle, their boat, will be able to carry their firearm without having to pay a fee or get a license from the government to exercise their freedom. That's what this amendment does.
Thank you, Mr. Sponsor. Are there any questions from the members in regards to this amendment? Yes, sir. Representative Hardaway.
Thank you, Mr. Chairman. Just looking for some clarification from the sponsor. So would this be open or concealed or both?
Mr. Chairman, thank you, Mr. Chairman. This would be either, exactly as the current carry permit allows. It would be for handguns, so this would not be long guns. That is a distinction. There are a couple different bills on this subject that all, in my opinion, expand freedom, but this would be restricted to handguns.
Okay.
But open or concealed.
All right, and those who have already paid the money for the conceal, and that wasn't cheap. Do they get a refund?
Thank you, Mr. Chairman. And thank you for the question. In fact, we are not doing away with our permit system. We are keeping our permit system in place. It's very important. I encourage folks to get a permit. I encourage them to go through that licensing process, get the training, and don't stop there. I mean, get training every single year. I have joked with some friends of mine before, and I do it jokingly and kindly, but if you haven't fired your firearm in a year, in my opinion, this is my opinion, not what the government requires, but if you haven't fired your firearm in the last year, you shouldn't be carrying it. You should be going out every single year and learning how to best utilize that firearm for your own protection and the protection of others. You should be learning about backgrounds. You should be learning about threat acquisition. You should be going through more and more intense training, how to safely store your firearm. We want folks to do that. The thing that this bill does, it takes the criminal penalties off of someone if they do not have that permit. It does not in any way take away the permit or take away the need and the desire of all of us for folks to get intense training with their firearm.
All right, just trying to get clarification on the permit. What will the state's role be in permitting going forward, and what benefits will the citizen get from seeking the permit, such as insurance? premiums.
Recognized.
Thank you, Mr. Chairman. So the benefits of having a permit are significant. I mean, there's reciprocity with other states. So, constitutional carry, when we hopefully pass it, and I, again, would deeply appreciate the support of this committee, when we pass it, hopefully, we'll protect individuals that are within Tennessee from being arrested for exercising their Second Amendment rights. But it doesn't affect any other state. And so a handgun carry permit, you need that for reciprocity with other states. There are certain sensitive areas that are currently in the statute that we're not touching any of those things. That's a bill for a different time that you would be still prohibited from going into unless you have a permit. So there are areas in the statute where those that have a permit may have a little bit of additional ability to go into certain areas versus those that do not. But we will not be locking people up in jail for simply not having a permit. I mean, that's what the current statute is. It is a criminal penalty if you do not have a permit, and that's simply inappropriate.
All right, and this should be my last question, but you always spur further thoughts, so I plan for this to be my last question. The age of eligibility or where you qualified, I know you cited the military and discharge, but otherwise, what is the age of eligibility?
So 21 and up for this particular piece of legislation in order to be able to fall within the protections of this bill. Now, it's 18 if you've been honorably discharged at that point, or if you are an active duty member of our military branches. And that just kind of makes sense. I mean, those, if you're 18 and up and you are serving this country, you are handling firearms of a much greater amount of skill is necessary to be able to safely utilize than a simple handgun. I mean, these are folks that are expertly trained.
All right, and this is an observation and not a question, so I'm still sticking to my original commitment. The medical research, as you're aware, neurological in particular, suggests that, I'm not going to put it fancy, I'm just going to say it, that most folks don't have a mature brain until they're 25. And the part of the brain that's last to develop is the part that controls impulse. So with that said, I'm going to ask that you consider raising the qualifying age to 25, and that's the end of my statement. Thank you, sir.
Representative.
So there are literally thousands and thousands of young men that storm the beaches of Normandy that would disagree with you that at 18 and up, they should be able to bleed for our country and die for our country and should be able to exercise all the freedoms of our country. So while their brain may not be as mature as possible, their freedom is as mature and should be protected.
Thank you. Next on our list
Mr. Chairman,
is...
if I may, just
All right, one more.
a clarification.
Yes, sir.
My grandfather, my father, all my uncles, my daughter is currently serving. So I'm not making reference to our veterans and our military personnel. What I was making reference to was the general public, that we consider raising that from 21 to 25. Thank you, Mr. Chairman.
Mr. Chairman and Representative, again, we're friends we've served for the years. I thought you were referring to the 18-year-old veterans and active duty members that I had just referenced, which was why I referenced the population that I did. So thank you for clarifying that, Mr. Chairman. Thank you.
Thank you. Chairman Howe, you're recognized.
Thank you, Mr. Chairman. And the sponsor actually covered what I was going to ask about, but I think it's worth repeating. If someone is traveling outside the state of Tennessee and they are a permit holder like myself, then it behooves you to have a permit and go through the training, because the states that I travel through have reciprocity with the state of Tennessee. If you do not intend to travel outside Tennessee, you can constitutionally carry a handgun in the state of Tennessee without a permit. Is that correct?
Yes.
Thank you.
Thank you. Reminder, members, we are on Amendment 1 in discussion right now. Representative Beck, you're recognized.
Thank you, Mr. Chairman. And come back to me, we're on the bill. I apologize, I was a few minutes late. And I thought we were on the bill and we're on the amendment. Thank you.
Representative Griffey.
Thank you, Mr. Chairman, and thank you, Leader Lambert, for bringing this bill. I fully support the effort. I'd like to get the language a little closer to my bill, but I fully support making progress on this, and thank you for bringing it in. Thank the governor for taking this step forward. Thank you so much.
Any other questions or comments on amendment number 1? Question has been called. We're now voting on adding amendment number 003738 on the House Bill 786. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. The amendment is added on to the bill. There is a second amendment here, Mr. Sponsor. Motion's been called. Question 004089. You wish to proceed with this amendment as well?
Yes, sir, Mr. Chairman.
Okay, you're recognized.
Thank you, Mr. Chairman. So the previous amendment, again, as I discussed, wiped out all the criminal penalties against lawful gun owners. So if you're a lawful gun owner, based on that previous amendment, again, you face no criminal penalties. Now, there are some prohibitions that were in there that were based on the premise that everyone would have a permit. And so if we wipe those out, this amendment puts back in certain criminal penalties separate from the constitutional carry amendment and portion of this bill. It puts them into the criminal portion of this bill. And again, I would remind members when we're back on the bill, and I may reference some of these, there are significant enhancements and increases of penalty for those that steal firearms, felons in possession of firearms, those that commit dangerous crimes with firearms. Those are on the bill. This amendment will add in a B misdemeanor penalty for anyone who has been convicted of stalking. Now, I have a bill that is later today in another committee that a woman literally was being stalked by an individual, and that stalker killed her husband right in front of her, and he is still sending her letters from prison. And we have a bill that will hopefully try to address keeping her safe. If you're convicted of stalking, you're not going to be able to carry under con carry. It would be a B misdemeanor. You're currently not allowed to get a carry permit if you're convicted of stalking. If you're convicted of 1 DUI within 5 years or 2 within 10 years, that is exactly what the law is now. You cannot get a permit. If you are convicted of DUIs, every single DUI literally is an attempted vehicular homicide. Don't drive drunk. If you want us to be able to protect your liberties here, don't drive drunk. Just don't do it. So, but that's preserving what's currently in the law, and it would still be a B misdemeanor if you are a convicted drunk driver or intoxicated driver, and you carry your firearm outside of your vehicle, home, business, and everything else. If you've had a judicial commitment, this is an involuntary commitment. This is not a voluntary commitment where someone has gone in and gotten help on their own. This is when 2 doctors have analyzed someone's background, a judge has had an opportunity to have a hearing on that, and they have had an opportunity for counsel. This is if someone has been mentally committed or has had a conservatorship put over them. Exactly what the law is now. Those are individuals that would not be able to take advantage of the con carry bill that we've just passed. And finally, we reference the federal code that says if it is illegal for you to possess the gun, if you're a convicted drug dealer, if you're an illegal immigrant, if you are in many different categories that are currently prohibited for you to even possess a gun under federal law, you would not be able to constitutionally carry here in this state. Under those 4 categories, we are adding that back into the criminal section of the bill, and it makes it much cleaner than the original version. So we keep those individuals, make it very clear to them that they may not carry, but we open it wide open for all other lawful gun owners that have not been convicted of crimes or adjudicated mentally defective. That's the amendment, Mr. Chairman.
Thank you. Are there any questions for the sponsor, Representative Beck, and then Hardaway after him?
Thank you, Mr. Chairman. Leader, in reading this about the mental defective adjudications, the police officer, as we learned from testimony last week, cannot find out currently if they've been adjudicated. There were 68,000, I believe, people in Tennessee who were adjudicated who are not supposed to be carrying a weapon. So I'm Joe Policeman, and I walk up to an individual, have no idea if they can carry or not. How am I supposed to know if he's broken the law for this new adjudicated mentally defective penalty that you've put under your bill?
Yes, sir, and thank you, Mr. Chairman. And again, this is not new. This is what's in the current code, where someone is prohibited from being able to obtain a carry permit now. What we are doing is we're retaining a B misdemeanor criminal penalty, and the way they would do it is the exact same way if they were to come into contact with an individual in their home, their business, their vehicle, their boat, their bicycle. They already don't have access to that system, and that is a problem, one that we should remedy. I mean, that system should be accessible to law enforcement on individuals, and you know, in your job, in your real job as an attorney, that we don't have a unified court system here, and so much of that is in the court records in, say, a specific county courthouse somewhere. That really does need to be compiled on individuals that have been, again, adjudicated mentally defective, involuntary mental commitments. We have a problem there. This bill doesn't dive into that, but I certainly believe that we should, because based on the testimony we heard last week, law enforcement comes into contact most of the time, from the testimony we heard, with folks in their home, their business, their vehicle. I mean, a lot of stops are made out there. Very few stops are made of somebody who's just walking down the street. That happens more in urban areas than in rural areas, but it's just not something that is a regular occurrence where law enforcement are stopping individuals that are just walking down the street. So what we're talking about with this bill is a tiny scintilla of interactions with law enforcement, and what you're referencing, in my opinion, is a much larger issue that we really should address, so law enforcement should have access to that system.
In the testimony last week, you kept referring back to a boat and a house. In the boat and the house, if they've got their permit and are legally allowed to carry, they can show their permit right then, and they can know if they've been adjudicated or if they should not have a permit. That's where the permit comes in so beautifully, is that if the police officer can immediately know if by running that permit, if it's still valid, and if it's still valid, they don't issue that permit if you've been adjudicated, correct?
Yeah, thank you, Mr. Chairman. No, I mean, that's the problem with the system now. I mean, it's not connected together well enough. I'm loud and clear going to say an officer should never just take a permit on face value. That permit could have been revoked the day before, the week before, and in fact, if it was revoked just the week before because of someone's mental health issue where they've been adjudicated for a committal, then the officer should investigate. If there's any indication that they believe where that individual is having mental health issues or they're picking up any kind of signs that they might have been adjudicated mentally defective, they should investigate that further. They should never just take a permit and even run it through the system, because that system takes time. Somebody could have been convicted of a felony the day before, and it takes sometimes weeks or even months for that to get into the system and for that permit to be revoked. That officer should investigate and look into that circumstance. But no, sir, a permit alone on its face, there's not somebody out there running out there literally revoking physical permits. They're supposed to send it in. But at the same time, we're talking about folks that have either been convicted of felonies or been adjudicated mentally defective. These are not folks that normally are going to just send in their permit. So no, the presence of a permit alone should never end the investigation.
But a permit is prima facie evidence that you are able to carry that weapon. Because if you are mentally defective, that stops them from getting a permit from the beginning. So if they've been mentally defective their whole lives, they can't get that permit, correct?
So we have lifetime permits in Tennessee. So, I mean, that was part of the discussion we had in discussing lifetime permits, is that someone could get a permit when they are perfectly sane or when they've not been convicted of a crime, and then that permit is good until revoked. And so, again, the presence of a mere permit should never be prima facie evidence that that individual is lawfully in possession of a firearm. The officer needs to do their job and investigate that circumstance just like they do. But no, sir, I would disagree vehemently that the presence of a permit, even if they run it in the system and it says it's good, they should still look into that if they're getting any kind of evidence that there might be an issue there. The permit alone should never be prima facie evidence that that person's good to go.
Representative.
But again, you can't get that lifetime permit. You can't get any permit if you've been adjudicated, correct?
As long as it was properly entered into the system. Now, not every clerk's office sends it in, but again, that system has issues. But when they run you for a permit, they do check those systems. And if the information was accurate in there, which from what we've heard is not always true, I mean, that system obviously has some holes in it, and we need to address that, I think. But no, again, just getting the permit, you could have gotten the permit when you were 22 years old, adjudicated mentally defective or have an issue when you're 42 years old, and you may still very well have that permit. It's just the permit alone is not evidence of anything other than at some point you were able to get a permit. It is not evidence that you were lawfully in possession of a weapon, and every officer should investigate each incident on its own.
Representative.
But again, and I know you're a great lawyer, but you have to agree with me, if you've been mentally adjudicated, you cannot get that permit to begin with, correct?
No, sir, I disagree. There are definitely holes in the system, even in the permit process, where someone could. That is the problem with the permit system and with the way that mental health adjudications are entered in. You are not supposed to get a permit, but you absolutely could, and I cannot tell you that it has not happened where someone has gotten a permit in that circumstance. So no, sir, it has nothing to do with my profession or yours. It is simply a factual issue that is inaccurate.
So you're saying you're not supposed to. That's the law as we stand here today, correct?
Yes, that is correct. That is the law, and it will remain the law in this bill.
Yes, sir.
But with this bill, we're putting our police officer at risk to go up and ask these people questions to determine, because they can't look on their laptop, or they can't, there's no way for them to know if they've been adjudicated at the scene right then. Is there?
Again, Representative, there's no way now. Just checking a system or even just looking at the permit is not an investigation. That's part of an investigation. But no, I mean, every officer's at risk every single time they're coming into contact with someone who may have mental health issues, or, every time they're investigating a crime on the different issues that are there, and they should do their job fully. They do it every day wonderfully. And the officers that I deal with in our community, and I hope in yours as well, would fully investigate that incident.
Yes, sir.
But the permit is supposed to be revoked if you're domestic, if you're arrested for domestic, or if you're adjudicated incompetent, correct?
Supposed to be. And
Supposed
again,
to be.
in many instances, it is not. And even in the system, if it is revoked, they will still retain the physical card in many instances. They are supposed to send it in. Again, supposed to. But the population that we're talking about here, it just doesn't always happen. So that is not in itself proof of anything, just having the card.
Yes, sir.
So law enforcement now would, if somebody's got a permit, they would take their permit and they would call in and see if it's still an active permit. Theoretically, and I understand what you're saying about some fall through the cracks, but theoretically, that would tell them if they had been adjudicated or if there was a domestic hold on that permit.
It would not. It would not, no. I mean, the system is simply not that good and not real time. It is one brick in the wall of determining whether or not that person, and in most instances, that probably would indicate whether or not that permit is valid, but it's simply not real time. The system's not that good yet. It should be, but it's not like the moment somebody is adjudicated mentally defective or convicted of a felony that it immediately goes in the system. There's lag time. There's issues there. And again, the data is only as good as what's being entered, and what we heard from our law enforcement officers, they don't have access to all those systems. The state has access to most of them, but we do not have a unified court system, and so it's simply not real time. I cannot push back hard enough on this. Never, ever, ever should an officer take just that permit or even it popping up in the system as evidence that an individual is lawfully within their right to have that firearm. If there's any other evidence where they feel like they should investigate further, they should, because that system is far from perfect.
But again, theoretically, and they're supposed to be able to rely upon that. I keep hearing you say, we fall through the cracks, and that's just another brick, and that's another brick in the wall that I would like to give our law enforcement. So that's the reason I'll have to oppose this. Thank you.
All right. Thank you. Representative Hardaway.
Thank you, Mr. Chairman. Let me be clear, I'm not a lawyer, I'm a lawyer's daddy, and I'm just a lawmaker, so I'm not going to engage in the legal tangles that you and Beck did. I'm going to keep it simple. because you've covered, actually, just being serious, you've covered most of the questions I was going to ask. So I'm going to just make two statements here. I'll make one of them twice. One of them is just that, to me, this kind of turns into an honor system for criminals, okay? The second is, I understand the back and forth and you stating that there are inefficiencies in the permit system that need to be cured. I'm going to look for a bill, and if I don't find one, I'm going to do a late bill filing and bring it to you and ask you to join me in curing that inefficiency before we finish this session, so we don't have that risk for our law enforcement officers and for the community. Thank you. Thank you, Mr. Chairman.
Thank you, Representative Vice Chairman Sexton.
Thank you, Mr. Chairman. Leader Lambert, I wanted to bring up the point that in your mind, I think this bill is called constitutional carry. Is that correct?
Yes, sir, not just in my mind. I mean, it is constitutional carry. I mean, there are some criminal penalties that are included within here that enhance penalties on, again, convicted felons and stalkers and everything else. But the portion of this bill that was in the previous amendment is constitutional carry. It preserves your constitutional rights.
What does that mean, constitutional carry?
Yeah. Mr. Chairman, and thank you for asking that question, Mr. Vice Chairman. I mean, you know, the Second Amendment preserves your right to bear arms. It's an individual liberty. It's been found that way by the U.S. not only U.S. Constitution and Bill of Rights, but by the U.S. Supreme Court and D.C. v. Heller. I mean, it is an individual right to bear arms that shall not be infringed. And if you're convicted of a crime or declared mentally incompetent, it can be infringed because of those circumstances. But for every other law-abiding citizen out there, every single American, I mean, your right to bear arms shall not be infringed. And that's what the amendment that we just passed a second ago does. It prevents any infringement on your right to bear arms.
So it's my understanding, and I will ask you if you agree with this, that whenever that the permit was imposed, it would be unconstitutional. And what we're trying to do here is to bring it back into agreement with the Constitution that we have the right to keep and bear arms. And we as lawmakers, as you've done with this amendment, you're wanting to protect the law-abiding against the lawbreakers by saying that if you've committed these offenses, you're going to lose some privileges. But your constitutional right, according to the Second Amendment, is that you have that freedom as a law-abiding citizen. You don't have to prove to anyone, to law enforcement or anyone, that you're a law-abiding citizen. Would you agree that that is the essence of your bill, and all of this talk about a permit is really not relevant to our Second Amendment right?
Please.
Yes, sir, absolutely. I mean, and in fact, in the permit system, it requires you, if asked by an officer, to present your permit and basically be inspected anytime you want. So not only are you giving up your Second Amendment rights, you're giving up your Fourth Amendment rights under the permit process. That's simply wrong. I mean, under the Constitution and the Bill of Rights, you have a right to be free from government encumbrance in your life. And both the Second and Fourth Amendments say you shouldn't have to do that. This bill resolves that, and by the way, it prevents you from being thrown in jail for merely exercising your Second Amendment right when you've done nothing else wrong. Our current law, unless you get permission from the state and pay a fee and go to a class, by the way, a one-time class that hypothetically is supposed to be good for the rest of your life, and that's laughable for anybody that deals with firearms. I mean, regular training is what's needed. But, I mean, under our current permit process, it is, I think, certainly a violation of your Second Amendment, Fourth Amendment rights, and others, because unless you've got that permit and paid that fee, you can't fulfill the destiny that our founders intended in this country to be able to exercise your freedoms.
One more question, and then I'll conclude. Maybe it's more of a statement than it is a question. I want to commend you for bringing this legislation to help us to gain back some of the freedoms that we've lost. Certainly, that's what it is. It was never required for a permit, and all this talk about permit is unconstitutional. I wish that we would understand it that way. Thank you. I'll be voting for this.
Thank you. Any other questions? Representative Beck, I'll give you one here.
Okay, just real quick. Permitless carrying is not to restrict someone to have a permit to carry is not unconstitutional. That has been tried over and over. As you're very well aware, Representative Sexton, there is you can put certain temperaments on the Constitution, such as I can't yell fire right now, and that's not violating my freedom of speech. So it's been tried over and over. Constitutional carry is not an absolute right when you're talking about the safety and welfare of our police and other citizens. So I just wanted to make sure that everybody understood that. Thank you.
Yes, sir, Representative Sexton.
That's the most ridiculous thing I've ever heard. Constitutional carry is just that, constitutional carry. Sometimes the courts get it wrong, but our forefathers got it right. And no matter how much you say it or how you say it, this right shall not be infringed upon. It was given to us by our forefathers. And with all due respect, you're an attorney, I'm not, and I don't mean that to disparage you, but I honestly do believe it's a ridiculous argument. Thank you.
Leader?
Mr. Chairman, I will say, and Representative Beck, who knows the law very well, and legally speaking, what he has said is under the law and under what the rulings have been, your rights can be curtailed. But we can also grant greater rights here in Tennessee than are granted under the U.S. Constitution. And we are choosing, in the passage of this bill, to grant greater rights. And I will reference that back in the 70s, there were certain cities that thought it was a good idea to ban firearms in their cities completely. And thankfully, our U.S. Supreme Court struck that down in D.C. v. Heller and found that you have an individual right to bear arms. It's not connected to the militia section of the Second Amendment. That's a separate clause. It is separate from your individual right to bear arms. And so, while both gentlemen have have stated accurate comments, I just want to say what we are really doing here is choosing to grant greater rights under the Second Amendment than the bare minimum that is required under the U.S. and federal standard.
Thank you. Members, a reminder, we are on Amendment number 2. We have not put that on the bill yet. Question has been called. You want to speak on this amendment, or would you question on the amendment? You have a question, or you're calling the question?
I've got a question.
You have a question.
Yes.
Representative Howell, will you withdraw your motion? Okay. Representative Russell.
Thank you, sponsor, for bringing this amendment. I do have a question. Would the officer, if they suspect a person carrying a weapon, would they have to have probable cause or reasonable suspicion to run their names?
Yes, I believe that they would, again, just as they would now. So if you have no reason when you come into contact with someone in a vehicle, you're not required to have a permit in your vehicle. And unless an officer has reasonable suspicion or probable cause to at least check deeper into their background, there's no reason why they should do so.
I think it's a great amendment, and I appreciate you bringing it to us. Thank you.
Thank you. Question on the amendment has been called. Members, we're now voting to add amendment number 004089 onto House Bill 786. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We're now on House Bill 786 as amended. By Leader Lamberth, you are recognized.
Thank you, Mr. Chairman. I stand ready for questions.
Okay, we are now voting on, objection will be voting on previous question. All those in favor say aye. Aye. Those opposed? No. The ayes prevail. We're now on we're now voting on the bill, 786 as amended. All those in favor of sending House Bill 786 to full criminal, say aye. Aye. Those opposed, no. The ayes prevail. If you wish to be recorded as a no, please see the clerk.
Thank you, Mr. Chairman and members of the committee.
Representative Hardaway.
Thank you, Mr. Chairman. Just wanted to point out a couple of procedural items. Number one being that Representative Beck did declare earlier in the questioning on amendments that he was holding his question for the bill itself. And Mr. Chairman, in essence, when we don't allow questions on the bill, if one of the amendments did not rewrite the bill, then we have not had debate on the bill. So I want to make that point and ask that my colleagues would be a little slower on the questioning, calling the question. Thank you, sir.
Thank you. Next item on our calendar, we are going to move to House Bill 18, which is item number 25. By Representative Griffey. We have a motion and a second. Representative Griffey, you're recognized.
Thank you, Mr. Chairman, members of the committee. I'm asking for a roll call vote on this bill. This is House Bill 18. It's constitutional carry. It differs from 786 in the aspect that it only outlaws if you're legally entitled to carry it as a Tennessee resident or in the state you're from, and you're 18 years old. It also makes a distinction between a handgun as provided in 786 and House Bill 18 says firearm. So that's a major difference between the two. I would like to point out for members of the committee, when the Second Amendment was passed, individuals were allowed to carry the state-of-the-art firepower back then, and it was adults. Through the years, that constitutional right has been eroded, and I applaud the Tennessee General Assembly, the governor, for let's take a stand, let's correct that erosion of our constitutional rights, and ask for a vote on this. Thank you. Available to answer any questions.
Thank you, Representative. Are there any questions for the sponsor? Representative Beck.
Thank you, Mr. Chairman. Representative Griffey. So the difference between your bill exactly and Representative Lambert's bill is what? Could you tell me in the Cliff Notes?
You have to be legally entitled to possess a firearm under Tennessee law. You can be 18 years of age, and it can be a firearm. House Bill 786 provides that it can only be a handgun. You must be 21 years of age. Those are the major distinctions.
Representative Beck.
Thank you. We heard last week from a businessman representing hundreds of businesses who is a Republican who told us how this would hurt business, especially the tourism business here in Nashville. You know, we also heard from law enforcement how this would endanger our law enforcement, our police, and police chiefs, sheriffs, TBI have all opposed this permitless carry. Why should we vote for something that is not making us safer or is not good for business? Why should we do this?
Thank you very much, Mr. Chairman, and thank you, Representative, for the question. You know, those same arguments were raised in all other 18 states for people that oppose constitutional carry, and guess what? In none of those states have the legislature sought to revisit and withdraw the laws that they'd already passed. I submit to you that more people that are law-abiding, that have firearms or the ability to carry firearms will deter crime. You see lower crime rates in states that have constitutional carry generally overall as opposed to some of our most restrictive gun law jurisdictions, such as Chicago, Illinois, and New York City. That's a proven fact. Thank you, Mr. Chairman. Thank you, Representative.
Would it surprise you to know that in my research, 15 out of the 25 highest rates of firearm fatalities, 15 are permitless carry states, number one. Number two, Memphis, Tennessee has a higher firearm fatalities than Chicago, Illinois. So I don't see from the statistics that your theory about this permitless carry, the Wild Wild West here, making us more safe in any shape, form, or fashion. Can you speak to that?
Thank you, Mr. Chairman. Yes, I'd be happy to. If we pass permitless carry, it will certainly make those who choose to carry and not get a permit more safe. They will have the ability to defend their lives against somebody if they're filling up in gas and somebody pulls up and tries to rob them or carjack them or something like that. I see that every week. It seems like there's a new case in Memphis or Nashville that's going on. I don't feel like it's appropriate for the General Assembly to hamstring law-abiding citizens who want to protect themselves and their lives so they can make it home to their children and their family, continue with their jobs, without being able to defend their life if somebody pulls up and has a gun. Because I can guarantee you, the people will violate the gun laws already. They're doing it, and that's why we have so many gun violence in our metropolitan areas.
Would it surprise you to know that the highest per capita firearm fatalities are in Mississippi, which also has unpermitted carry? Do you think doesn't look like it's making the citizens of the great state of Mississippi any safer?
Well, I don't think that's really a fair and accurate argument. You're saying just because there's more gun crime going on there that constitutional carry down there hasn't made them safer. I don't see that as a logical argument. You could have both existing at the same time. You have a lot more killings and shootings in Chicago, Illinois. They have some of the most restrictive gun crimes on there. You're trying to conflate two separate statistical facts, and I don't think that they statistically support each other.
Representative Beck.
Well, you just made the statement that the point of this was to make us safer, and obviously it's not making people in other states safer. Why do we not just do away with the fee for the permits? Would that not break down the barrier that you're seeking to break down and still make law enforcement safe?
This bill is pursuing constitutional carry. You're certainly encourage you to pursue any legislation you feel is appropriate.
Very good. Thank you very much.
Thank you.
Thank you. Representative Hardaway was next on the list.
All right. Thank you, Mr. Chairman. Just a couple of questions, sir. As your bill progresses and as Lambert's bill progresses, will they at some point merge, or is it one or the other or both? You cited some differences, so I don't see how the both of them can become law without being in conflict.
Thank you, Representative. I have no control over which bill is going to get where. It's up to the will of the members of both the House and I believe the Senate version, and which one actually gets there. I'm not sure how it will actually play out.
Okay, you want me to make the call on that?
I'm here to answer any questions I can for you if I have knowledge of them about my bill. Thank you.
All right, let me get back to being serious. Is yours considered to be pure constitutional carry versus Lambert's being permitless carry? Is there a distinction there?
I've tried to outline the distinction. Mine says firearms. House Bill 786 says handguns. I believe 786 lists restrictions of 21 and older. My bill says 18 years old, about 18 years or older, adults.
Okay. Thank you.
Representative Hardaway, if you will excuse me, you referenced Representative Lambert, in your last comment, give him an opportunity to respond if he wishes.
Pass.
Okay, Representative Hardaway.
Thank you, Mr. Chairman. I hope he wasn't trying to give me a lead for the future. Call my name, I want to talk. Okay. So firearm for you, firearm means, not for you, but firearm would mean any gun, including long guns?
The definition of firearms in Tennessee code and federal code. So
Would that include long guns?
it's my understanding it would. You can refer to legal.
All right.
We wish to go out of session to hear from legal.
No, sir, I'm satisfied with the sponsor's answer. Let me give you one of my main concerns. I've got a serious issue in Shelby County with criminal gangs. I don't see how this makes the community safer. Hearing the exchange between the leader and my colleague on how law enforcement officers will be able to weigh reasonable suspicion, probable cause, when everybody's walking around with a weapon in every circumstance except those that are prohibited. So I just don't see how it makes the community safer. I'm sure the criminals are probably waiting to walk around with a weapon because they can't be challenged unless there's probable cause or suspicion. Can you respond to that?
Thank you, Representative. We do have a serious problem with firearm violence in a number of our communities. We shouldn't impose a violation of law-abiding citizens of their constitutional rights to try to address a illegal use, possession of firearms situation. I don't think we should use permits as an excuse for law enforcement to challenge individuals who are otherwise minding their own business and not violating any law, not doing anything to create a reasonable suspicion or probable cause to have an encounter with law enforcement unless they've done something. In America, we're protected by the Fourth Amendment to mind our own business. Law enforcement doesn't have a right to come in and check our homes, see what we're doing, show us your papers, and ask us what our business is, as long as we're not doing anything to create reasonable suspicion or probable cause that we're committing a criminal offense. And if we have the constitutional right to possess a firearm for our own personal safety, that's the way the Constitution is set up, and that's the way I feel the Constitution was set up. So,
Well, I certainly appreciate your defense of the Second and Fourth Amendment rights. I disagree with your overall bill, but I thank you for that. And I still feel like it puts my community and the rest of the great state of Tennessee in peril. So I'm going to have to vote against your bill. Thank you, Mr. Chairman.
thank you, Representative. In fact, I could just say I would certainly join any effort for we can make a public campaign in all of our communities to try to make them safer, get people good paying jobs, turn away from the culture of violence and drugs. And drugs are probably generate most of the firearm violence in our communities. I think if you ask most DAs, that's what it relates to, because people, you can't use law enforcement to solve a dispute if someone didn't pay you for your drugs. So what do? You pull out a gun and you try to shoot and self-help your way out of the situations. And we need a public campaign and effort in all of our communities to try to turn away from the drugs and the violence. And I'll support any bill that will do that. Thank you, Representative. Appreciate you.
Thank you. Any other questions, Representative Russell?
Thank you, Mr. Chairman. Thank you, sponsor, for bringing this bill. I also believe in the Second Amendment. I do have a question. In your bill here, it says who is legally allowed to be in possession of a firearm. Where do you get who is not legally allowed to be in possession of a firearm?
That's referenced in another part of the Tennessee Code and 18 U.S.C., Federal Code, 18 U.S.C. 922G, lists a number of provisions. You can't be a convicted felon, be illegal alien, mental defective, drug abusers. There's a number of specific provisions spelled out in Federal Code, and we have additional state law provisions on some of those.
Thank you.
Thank you.
Vice Chair Sexton.
Thank you, Mr. Chairman. This bill is just another form, very little difference from the one that Leader Lambert has. That correct? You've explained that difference. Just want to say thank you for standing up for our Second Amendment rights and for securing our freedoms that we're losing on a regular basis. So I appreciate you and both you and Leader Lambert and your bravery in taking on this monumental task, and I applaud you for that. Thank you.
Thank you.
Thank you. I will take an opportunity to ask a question here that I would have asked the sponsor of the previous bill the same question. How does your bill line up with Article 1, Section 26 of our state's Constitution?
Thank you, Mr. Chairman. I think that this fully complies with Article 1, Section 26 of the Tennessee Constitution. Says that the right to bear firearms shall not be infringed by the General Assembly except with a view to deter crime. And this bill is not, if we pass this, I think we're going to deter some crime. And I may not have quoted the exact words. So.
But you would say that it does add to our common safety and defense that would be outlined in that?
Absolutely.
Thank you. Any other questions for our sponsor? Representative Russell.
Thank you, Mr. Chairman. I just thought about something. In Tennessee, is it still 21 years of age to buy bullets?
It's my understanding it's not. You can buy bullets at 18. I'd have to refer to legal.
Okay, thank you.
Thank you. Seeing no other further questions, any objection to calling the question? Question has been called. All those in favor of sending House Bill 18, a roll call vote has been requested earlier by the sponsor. Madam Clerk, please take the roll.
Representatives Beck?
No.
Curcio?
Aye.
Farmer?
Aye.
Griffey?
Aye.
Hardaway?
No.
Howell?
Yes.
Lamberth?
Yes.
Moody?
Aye.
Russell?
Yes.
Sexton?
Yes.
Chairman Doggett?
Yes.
Mr. Chairman, you have 6 ayes, 2 noes.
Thank you. The bill will proceed on to full criminal next week. Thank you.
You're right.
I was watching your count and you threw that one off on the side of it. Members, we are going to item 1 on our calendar. Item 1, House Bill 1047. I believe that's going to be carried by Representative Russell. We've had a motion and a second. You are recognized. There is an amendment, Representative Russell, 004137. You wish to proceed with that amendment?
Yes, Chairman.
Okay. You have a motion and a second on the amendment. Go ahead, please.
Thanks, Chairman and Committee. The amendment makes the bill, and what House Bill 1047 with amendment attached does is it requires that after conviction of certain crimes that historically targets women and children, 100% of the imposed sentence must be served. Sentences cannot be reduced by credits. However, credits can be used for the purpose of increased privileges, reduced security classifications, or for any other purposes other than reduction of the sentence imposed by the court. Plain and simple, if you do the crime, you do 100% of the time, no possibility of parole or probation. For example, if an individual is convicted of rape, the average sentence is 7.05 years, and the average incarceration is only 4.64 years. If an individual is convicted of sexual battery, the average sentence is 3.26 years. However, they're only on the average incarcerated 2.41 years. If an individual is convicted of child abuse, neglect, or endangerment of a child under 6 years old, the average sentence is 2.09 years. However, they only serve 0.76 years. This is a broken system that this legislation is going to fix. However, what this bill does not do, the legislation does not remove the judicial discretion for imposing sentencing. Thank you, Mr. Chairman.
Thank you. Leader Lambert, you have comment.
Thank you, Mr. Chairman. And Representative Russell, I want to thank you for carrying this for the speaker, and I want to thank our speaker for the bold leadership here on putting forth a piece of legislation. And we talk about criminal justice reform all the time, and really what that is setting our penalties on different crimes and setting, what the punishment should be at an appropriate level. Most of these crimes in this amendment historically have been committed against women and children. And for all of us, hopefully in a bipartisan way, to be able to stand up and say, once you've availed yourself of the entire criminal justice system and you've been convicted of these type of heinous crimes, you should not be eligible for parole. Now, I think everybody's heard me talk at length about going in and redoing our entire sentencing code. This and a couple of the other bills that will hopefully come in the next few weeks are a big step forward to remaking our criminal justice system. But this amendment goes after the worst of the worst. Thank you for carrying it again. Thank you for our speaker's bold leadership on this issue.
Thank you, Chairman Curcio.
Thank you, Mr. Chairman, and I want to echo a lot of that. To the sponsor, we talk a lot about who we're mad at versus who we're afraid of, and these are people we are absolutely afraid of. These are some of the worst criminals in our society, and I think truth in sentencing is very, very appropriate for these folks. So I want to commend you. I was honored to sign on to this bill as soon as the amendment was available and I saw what this was all about. But these are the worst of the worst. And that is exactly why we've got to reform our system so that we've got enough beds for all the bad guys. And these are the bad guys. So thank you very much for bringing this bill, and I'm honored to be a co-sponsor.
Thank you. Anyone else? Any objection to Representative Griffey?
Thank you, Mr. Chairman. I fully support this bill as well. I was thrilled the speaker brought this legislation, and happy to co-sign on too. Thank you.
Thank you. Any objection to calling the question on the amendment? We'll be adding amendment number 004137 on the House Bill 1047. All those in favor say aye. Aye. Those opposed, no. The ayes have it. We are now on House Bill 1047 as amended. Question has been called on the bill. Without objection, we'll be voting. All those in favor of sending House Bill 1047 as amended on the full criminal say aye. Aye. Those opposed, no. The ayes prevail. Moves on to full criminal. Thank you. Next item on the calendar is number 2, House Bill 49 by Vice Chairman Ogles. Motion. There's a motion and a second. There is an amendment. Motion on the amendment. Amendment is number 002687. We have a motion and a second on the amendment. You wish to proceed with that amendment?
Yes, Chairman, thank you. And members of the committee, the amendment was simply clarifying a typographical error that I made. But
question's been called on the amendment. We'll be voting on adding this amendment on to House Bill 49. All those in favor say aye. Aye. Those opposed, no. The ayes have it. We are now on House Bill 49 as amended. You care to withdraw that? Okay, Representative Hardaway.
Thank you, Mr. Chairman, and thank you to the member for withdrawing. What is the enforcement mechanism for those agencies that don't abide by the 30-day rule?
thank you, Chairman, members of the committee. This piece of legislation doesn't specifically address the enforcement mechanism. This is simply placing in statute that there is a requirement of, right now it says 60 days. This piece of legislation would lower that threshold to 30 days in which law enforcement agencies submit sexual evidence for crimes to the state TBI crime lab. And members of, as you will remember, several years ago we had a substantial problem with backlog of evidence. This bill is a piece of legislation to help remedy that, and I'm thankful for all the input from law enforcement to take this burden on themselves. This will increase some of their times and their trips and presenting this evidence, but this is something that they decided to do very willingly, and we're cooperating with this reduction in requirement.
And I thank you for the legislation. I would caution that as we move forward, we've got to be conscious that if this is going to mean anything, two things. That one, we've got to make sure that we've got enforcement mechanisms. We've got to be able to hold these agencies accountable. The second is that we've got to make sure that we properly fund TBI so they can get the job done. So I'm supporting your bill, and I'll ask that you and my colleagues consider those two issues.
Thank you, Chairman. Yes, and as we arrived, I guess 2 years ago, as some of the freshmen here, I guess 5 sessions ago in 2 years, that was one of the things that we were surprised about, and that's not a deficiency on the part of TBI. That crime lab is funded by the General Assembly, and that's our responsibility to give them the funding that they require to do their jobs effectively and quickly. I think as we've seen commerce increase in the effectiveness of how we get things almost immediately, I think at some point in the very near future, it would be nice to see that criminal evidence was processed in a very quick and effective manner. But thank you for those comments.
Thank you to the sponsor. Representative Russell.
Thank you, Mr. Chairman. This doesn't affect the chain of custody or the rules of evidence, does it?
Thank you, Chairman. No, sir, it does not.
Thank you.
Thank you. Leader Lambert.
Thank you, Chairman. And to that last comment, I do want you to put on the record that there is never to be any finding by any court that there was a legislative intent to affect the evidence that would come in just because somebody were to send in this type of evidence of a horrendous crime on day 31. I mean, that should still be admissible. We want the courts to still make that admissible. You are setting a standard that you would hope they would all comply with, but it should never be to the benefit of some defendant that it arrives a day late. Is that your intention, sponsor?
Thank you, Chairman. Absolutely. This legislation in no way is to intend that any evidence filed beyond that date is not admissible in court.
Thank you. Representative Griffey.
Mr. Speaker, I just want to thank Leader Lambert for those comments. This is the intent of this bill is to indicate to law enforcement we want this evidence in the lab and processed within 30 days, if at all possible. There's no intent that this evidence should ever be excluded if it doesn't make it by those timelines. So thank you. I just want to put that on the record.
Thank you. Any other questions or comments for the sponsor? Question has been called. We are now voting on House Bill 49 as amended. All those in favor say aye. Aye. And those opposed, no. The ayes prevail. Moves on to full criminal.
Thank you, Chairman. Chairman, would you like me to do that next piece of legislation while I'm up here?
Yes, sir, if you would. I believe that is going to be item number 9 that's on our calendar. I was looking for that. Thank you. Item number 9, House Bill 1343 by Chairman Ogles. You're recognized.
Thank you, Chairman, members of the committee. This piece of legislation addresses a problem that we've had in the state for many years, and I want to compliment the representative from Sumner County as well as the representative from Shelby County on working on this legislation in the past, and as well as the rest of this committee. Right now in the state of Tennessee, it is illegal to smuggle in a cell phone into a penal institution while somebody's incarcerated. However, once that cell phone makes it through that net we've cast, to actually possess a cell phone inside a prison is not an offense. And what we saw is the reason that is unfortunately a lot of these cell phones make it through. And the fiscal note on changing that in the past has been substantial to the point of an excess of north of $20 million. What this piece of legislation does is when we do find a cell phone, it makes it a Class E felony and imposes a fine only. First time, the judge will have judicial discretion on the fine amount. The second time a cell phone is found in a cell or in possession on a person incarcerated, that fine will hit the maximum amount, which is $3,000. And we hope this puts some teeth in the fact that these are not to be permissible inside the penal institutions, and we can help remedy a problem we have in this state. Thank you, Chairman. I'll take any questions.
Thank you. Representative Hardaway, you have a comment?
Yes, sir. And I thank the sponsor for the bill. The genesis of this discussion came about from a constituent, a family, who had lost a son in a murder. And the murderer was calling and posting on social media to intimidate, to harass, to mock the family about the murder of their son. So I thank the sponsor and consider me a strong yes and a strong co-prime on this.
Thank you. Any other? Representative Moody.
Thank you, Chairman. And just to add, I had heard from one of our the officers that work inside the prison. His story was he had the weekends off and was a divorced father, so he had his children on the weekends. When he would come back on Monday, the prisoners told him everywhere he had been with his children. And that was only because they had phones that they could get people from the outside following those correctional officers and then intimidating them inside the prison with that knowledge. So, good bill.
Any other questions? Representative Landreth.
Thank you, Mr. Chairman, and Representative Ogles. I actually had spoken to the individual that had this bill previously. I didn't know it had been transferred over, so we've not had an opportunity to talk about this. But I do support the legislation. I would like to talk to you between sub and full. I've carried bills like this in the past, and I think you're referencing that. And even though they had a fiscal note, I do want to make sure that we have some actual punishments. A fine only for somebody already incarcerated. I want to make sure we get with TDOC and make sure that that is going to in some way negatively affect them within the prison if it's just a fine only. And I know why it's a fine only. That's to avoid a large fiscal note. But we looked at several different options before, even some misdemeanor penalties. So I applaud your effort. I support it 100%. I support it passing this committee. But it sounds like there's large support to put some penalties in there. But if you wouldn't mind, at least let's get together and talk about what some of those penalties could be so that we make sure TDOC's got the tools they need. And this may do it. I just hadn't had a chance to look into that yet. Thank you, and it's a good bill.
Thank you, Chairman. I appreciate that, and as you all will know, sometimes legislation and legislative intent gets held up sometimes because of fiscal notes. So this legislation was written in a way to be sure this is something we can remedy immediately, and it would not be restrained because of a huge fiscal burden. If there's something, definitely, Leader, if there's something we can add that would not put this behind the budget and send it to that black hole that where a lot of good things seem to go, I would invite that, and I always appreciate your input. And thank you, committee, very much.
Thank you, Representative Hardaway.
Thank you, Mr. Chairman. And to try to keep it out of that black hole, let me add this. We were able to document instances where individuals in prison, as Representative Moody referenced before, are still carrying on their criminal enterprise while in prison, thanks to their access to the outside world and to their minions by cell phone. We're also able to document where prison escapes have been aided by cell phones within the prison. And we have lost the life of a prison guard, documented, where the actual escape was organized with the aid of a cell phone inside the prison. So I want to make sure that we get that on the record, and Mr. Sponsor, I'm with you on this. And thank you, Leader Lambert.
Thank you, Chairman, members of the committee. And this legislation doesn't address another issue that we also have a problem with in the state of Tennessee. It's that those smuggled in cell phones are in fact burner phones that are not registered to anyone. And if there's a mechanism in this state that's proliferating crime, it's burner phones that have no identification whatsoever, which SIM cards can be changed within 30 seconds, and law enforcement has next to no chance to track them. Thank you, Chairman.
Thank you, Representative Russell.
Thank you, Mr. Chairman and sponsor, for bringing this bill. In 2009, I had the opportunity to go to the TBI Academy, and believe it or not, I actually passed it. But so while I was there, we had a couple of the TDOC internal affairs people that was graduating also, and that's where I learned about these phones in the prisons, and it's going to save lives. And I appreciate being able to hopefully co-sponsor this bill with you, and thank you for bringing it.
Thank you. Any other questions? Any objection to calling the question? Seeing none, we're now voting on House Bill 1343. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. Move on to full criminal. Thank you.
Thank you, Chairman, members of the committee.
Members, we're now on item number 3, House Bill 578 by Chairman Reagan. A motion and a second. Chairman, there is an amendment entitled 0041.
Mr. Chair, before we consider the amendment,
Yes, sir, you're recognized.
I'm going to announce my intention to roll the bill to discuss that amendment with some of the members of this committee. Before I do that, I want to make a few comments, and then I'll roll it a week.
Okay, please.
The first comment is, for those of you that were not on this committee last year, this is the exact same bill that we passed out of this committee last year. It didn't get taken up by the Senate because of the the pandemic. The issue is, in this bill, is attempting to protect innocent minor children. The concern that has been raised by physicians in some cases has been that this bill contains a criminal provision for its violation. However, I think it's because of a misunderstanding that they're raising this issue, because a portion of this bill is already a Class D felony. TCA 39-13-110 is a Class D felony for physicians anyway. So this bill is only making sure that we don't get a discrimination issue, because 39-13-10 applies to females. This bill would apply to males and females alike. And so with that explanation, and hopefully setting the grounds for the discussion of the amendment that was going to be proposed, I will ask this bill to be rolled 1 week, knowing that we only have 2 before it goes to the last calendar. I'm assuming that my colleagues will understand the provision that I just talked about when we discussed that amendment. However, if anybody has a question before I step down, I'm glad to take it.
Do you have a question?
Yes, sir. I'm probably the only one that doesn't understand the issue of when you say that you're trying to make sure that the penalties don't discriminate between male and female. Can you clarify?
It is already a Class D felony under 39-13-110 for female genital mutilation, okay? This bill is addressing a therapy with hormones and potentially with surgery as well on genitalia. But it is also addressing males as well as females. And in fact, the penalty that I've requested in this bill is lower than a Class D felony. So I'm a bit concerned that the physicians are objecting to having it lowered, but nonetheless, I'm willing to discuss this with the individuals who were interested in the amendment.
Chairman Reagan,
Thank you.
your desire is to roll 1 week?
To address the potential amendment, yes, sir.
Thank you. Without objection, rolled 1 week.
Thank you, Mr. Chair and committee.
We are now on item number 4, House Bill 150 by Chairman Zachary. Properly motioned and second, you are recognized.
Thank you, Mr. Chairman. Members, fairly simple piece of legislation. This legislation is supported by Mothers Against Drunk Driving and Anheuser-Busch. It is related to social hosting. Chairman Curcio and I worked on this a little bit last year, but COVID derailed the process. This simply changes the word underage to minor. Right now, in code related to social hosting, it can only be prosecuted if the person social hosting an event allowing minors to drink alcohol at their property is between 18 and 21. So we're actually changing the word underage to minor, which includes anyone under 21. So if a parent is hosting high schoolers at their home, it would be a Class A misdemeanor with a $1,000 fine and community service. With that, I'll be glad to answer any questions.
Thank you. Any questions for the sponsor? Seeing none, the question has been called. All those in favor of sending House Bill 150 to full criminal say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal. Thank you.
Thank you, Mr. Chairman and committee.
Member, item number 5 on our calendar, House Bill 1074, has been rolled 2 weeks at the request of the sponsor. We're on item number 6. House Bill 384 by Chairman Crawford. We have a motion and a second. You are recognized.
Thank you, Mr. Chairman. Thank you, committee. Most people on this committee are going to be familiar with this. This is a bill that was brought last year. It passed out and didn't get taken up by the Senate as a lot of other bills, as we've heard today. This is dealing with minor children, 12 years old and under. The bill is called Evelyn's Bill. This is from my county. In Sullivan County, we had an incident. A little 15-month-old girl, Evelyn Boswell, was murdered by her parents, and they did everything they could to give our local law enforcement and TBI the runaround. They were told that she was with the grandmother in North Carolina. They were told that she was with friends traveling and on vacation. And all this time, the little girl had already been passed. And it was devastating to my community. And we really felt like our hands was tied. There was nothing we could do. They were trying to interview the parents, and nothing ever was truthful. Nothing ever came out. So we went with the local law enforcement, the sheriff's agencies, the association, and we said, what can we do to help you guys? Because we never want another community to experience this again. And so we come up with Evelyn's Law. And basically what it does is it requires a parent or a guardian to report a child if they have been missing 24 hours. If they neglect to do so, they would receive a fine of, I think it's $2,500. They could serve up to 11/29 in jail, and it would be considered a Class A misdemeanor. If that child is found with serious bodily harm or death, then that moves up to a Class C felony with a possibility of 15 years in jail and a $10,000 fine. There was some questions on this dealing with how do we get around the fact of self-incrimination. And at that time, Judge Carter was serving on this. Judge Carter helped us put the information in there to take care of that. And with that said, I'll stand for questions.
Thank you. Are there any questions for our sponsor? Chairman Farmer.
And you may have answered this, and thank you, Chairman Crawford, for bringing this piece of legislation. I do remember this incident. It was terrible. It was atrocious, and it should never have happened, and I don't ever want it to happen again. And I know that's your intent and purpose of this, so thank you for bringing this legislation. First off, does this apply to any minor, 18 and under, or is it a certain age? I should probably already need to know this, but I should have known this, but yeah.
Thank you, Mr. Chairman. To answer your question, as was stated with Chairman Zachary, who was just up here, we used the word minor simply because that means 12 years old or under.
Okay. Thank you so much.
Thank you. Any other questions? Question has been called. Seeing no objections, we'll be voting on House Bill 384. All those in favor say aye. Aye. Those opposed, no. The ayes prevail.
Thank you, Mr. Chairman. Thank you, committee members.
Thank you. Next item, number 7 on our calendar, House Bill 881 by Chairman Terry. You have a motion and a second. Chairman, there are two amendments.
Yes, the amendment I'm going with is 4221.
Okay. Motion and a second on that amendment. You're recognized on that amendment.
All right, thank you. The amendment is, the only way that it differs from the original bill is that I have added a severability clause in the event that it's basically belt and suspenders. If something gets struck down in the bill, I want to make sure that the rest of the bill stays intact.
Okay. Thank you. Any questions for the sponsor? Question has been called. We're now voting on adding amendment number 004221 onto House Bill 881. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We're now on House Bill 881 as amended.
All right, thank you. 881 is designed to help protect the right to peacefully protest by Tennesseans by cutting down on bad actors that may escalate an otherwise peaceful protest into a riot. This bill is based on a psychological phenomenon called social contagion theory. Social contagion theory is when you have a group of individuals and one individual acts out or takes an action, it can become contagious within that group of individuals. So, for instance, if you have a group that is peacefully protesting and somebody decides to throw a rock or charge a building, it can become contagious within that group and escalate to a riot, which could cause otherwise peaceful protesters with good intentions ending up with a charge for rioting. The bill addresses this issue by enhancing the charges for someone who has been paid to riot or who has come in from out of state with the intent to commit a criminal offense. The penalties in the bill are Class C felony with a mandatory minimum of 40 days of incarceration or 60 days if more than one of these acts have been in the bill have been committed. Additionally, any conviction will include restitution for any injury, property damage, or loss that has resulted in the violation.
Thank you, Mr. Sponsor. Questions for the member? We have Representative Hardaway.
Mr. Chairman, come back to me after Beck, please.
Okay. Representative Beck.
Thank you, Mr. Chairman. Thank you, Chairman Terry. I was reading your bill and listening to your explanation. In the bill, it says, with the intent, someone from out of state with the intent or participating in a riot. Now, I understand the paid riot or somebody paid and how that would be a slam dunk if you can prove that. But how do you prove intent for someone coming in from out of state to participate in a riot?
Thank you. Thank you. Great question. Intent to commit a criminal offense. And so what that would be is, again, it would be up to the DA or whoever is going to prosecute this to determine how they wanted to know that they had that intent. But for instance, if somebody came across state lines and brought bats or bricks or something with them to participate in that, that would be potential intent. But again, it would be up to the DA to determine their intent for that.
Representative Beck.
You, in your explanation, you use the example of somebody throwing a rock during a peaceful protest to rile up the protesters. I just think that, and I understand there's already criminal laws concerning vandalism, and so I'm missing why we would need to escalate the penalties in this particular situation. Can you explain to me what your thought pattern is there?
Okay. Again, for if you're paid to riot, or if you have come in with criminal intent that escalates this, the purpose is you have otherwise peaceful protesters that are out there, and if somebody has an intent to basically escalate that to a riot, they've got intent or they were paid to do so, otherwise peaceful protesters now could get caught up in that, and then they could be charged with rioting. And what I would like to do is to ensure that we don't have these bad actors that are getting otherwise peaceful protesters and infringing on their rights and getting them caught up in a charge that they don't need.
Representative Beck.
And I agree with you on that premise, that if we have peaceful protesters and we have agitators or people paid to come in and incite, is what you're saying basically, that would not be the situation that we would want in our great state. I think we're going to have, where I have a problem with it is the proof is just about going to be impossible to me. I don't see how it's going to play out. That we're going to, now if you're right, if somebody comes in with dynamite or anything like that, or bats, things that they are going to incite. But other than that, I don't know. It's just it's leaving me out on a branch, and it feels like somebody's sawing it off behind me if I was trying to prove this. So, thank you.
Thank you.
Thank you, Representative Hardaway.
Thank you, Mr. Chairman, and good morning to the sponsor. You addressed some of my questions already. Because intent, it's difficult for me to get past that. If you're coming in to participate in a peaceful protest and it turns into a riot, but your intent was to participate in a peaceful protest, this bill would not apply to you. Is that correct?
That is correct.
Yeah. And I'm pretty sure that I know the answer, but in 2, A, B, and C, any one of those don't have to be in combination. It could be the travel with intent to commit the criminal offense, or exchange for compensation, or there's an injury or property damage.
Yes.
All right. Thank you, Mr. Chairman.
Thank you, Chairman Curcio.
Thank you, Mr. Chairman, and thank you, sponsor. I want to commend you for grabbing on to a subject that's been important to Tennesseans for a long time. And in fact, I went back and I looked at a special address that, being a Dixon County boy, I'm a Frank Clement fan, and Frank Clement addressed this General Assembly in 1957 when there was a lot of upheaval going on. And it's interesting, he actually identified this problem then and asked the legislature to think about this issue. He says, I'm not so concerned with what extremists on either side think about what I shall say here today, nor those out-of-staters who come into our midst stirring up trouble and strife where none existed in order to further their own gains. I shall not attempt to please them. He goes on and talks about how every great nation that's been built up over the past millennia has always typically fallen from internal strife and from internal terrorism and things of that nature. And so he asked the legislature then in 1957 to look at this issue. And so I'm sorry it's taken us this long, but I appreciate you bringing this bill, and I'm proud to support it. Thanks, sir.
Thank you.
Thank you. Representative Griffey.
Thank you, Mr. Chairman. Thank you, sponsor, for bringing this bill, and I'm happy to support it and co-sign on to it. Regarding the questions of intent, I think we have some excellent criminal investigators and prosecutors and sheriff's officials that they can look at social media posts, phone records, text messages. They can find out intent, and intent always becomes a question of for a jury to determine. So we don't want to get the innocent, but we certainly want to punish those that are guilty. So thank you for bringing it.
Thank you.
Thank you. Any other questions? Question has been called. We're now voting on House Bill 881 as amended. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. If you wish to be recorded as a no, please see the clerk. Your bill moves on to criminal full.
Thank you, Chairman and Committee.
We're now on item number 8 on our calendar, House Bill 428. By Chairman Littleton. Motion and a second. Chairman, you're recognized.
Thank you, Mr. Chairman. In 2019, the General Assembly passed a bill requiring all offenders who committed aggravated rape of a child to be sentenced to life without the possibility of parole. This bill would change the sentences for offenders who committed the crime as a juvenile and have been transferred to an adult court to be sentenced as a Range 3 offender. Offenders who were adults at the time of the crime will still receive life without the possibility of parole.
Thank you. Are there any questions for our sponsor? Seeing none, any objection to the question? Seeing none, we'll now be voting on House Bill 428. All those in favor say aye. Aye. Those opposed, no. The ayes prevail.
Thank you, Mr. Chairman and committee.
Full criminal,
Thank you.
thank you. Yes, sir.
Mr. Chairman, it's a moment of personal privilege. We can't have everyone here at the Capitol every day that we always would like, but we are open. We do have visitors today, but I just wanted to give a shout out to one of my constituents that's watching back home, Daryl Rogers. He's a friend of mine from high school, and there were several bills he was interested in today, and I know there are several folks that are watching us online, and I'm glad that we had that ability for, even if they can't make it down to the Capitol, that they're watching. So, Daryl, thanks for tuning in.
Thank you very much. Next item on the calendar, number 10, House Bill 1145 by Representative Grills. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman. This bill just places the word farm under protection of critical infrastructure. Back home, we've had several instances where we've had farms just totally vandalized. We've had pivots, the wire's been pulled off of pivots. They'll back a truck up to them, cut the wire, and start pulling the pivot wire off, and then they'll take them back home, burn the plastic off of them, take it to a scrapyard for whatever they need the money for. They've got instances where tractors been sitting in the fields, and they'll go take metal shavings and fill the hydraulic reservoirs up. We've had instances where cotton bales have been sitting out in the field, already harvested, and they'll go and burn them. I had an instance where a guy had these rollers that roll cotton, and they have look like big bales of hay, and they'll go out with a razor blade and just cut the protective coat on them. It's becoming a problem even more and more. But personally, I had a trailer truck burnt about 8 years ago, just sitting there minding its own business one night, and got up the next morning and someone burnt the truck to the ground. So this is an occurrence that's happening in my home or my part of the state pretty often. And I'm sure, Representative Moody, you've had some of the same issues. With that, I'd appreciate your support.
Thank you, Representative Moody.
I do agree with this bill. It is a great bill, and it is a huge problem for our farming community, and I thank you for bringing it.
Thank you, Chairman Howe.
Thank you, Mr. Chairman, and thank you, Representative, for bringing this bill. You and I talked about this bill, and I was reminded of incidents that's happened in my district recently, most recently, not that many months ago. I guess it was harvest season. One of the farmers in my district had almost his entire crop destroyed because a couple of hoodlums they looked to be in their early 20s, decided it was a great place to do donuts in their four-wheelers. And he happened to catch them in the act, and they, in return, accosted him. He was hurt, seriously hurt. But he had no retribution. He had no recourse. So this is a good bill. We need to protect our farmers because if you eat today, thank a farmer.
Thank you, Chairman. Chairman Curcio.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing the bill. We met on this and understand. I fully agree with everything that's been said here. We definitely want to protect our farming community. I am, though, concerned, and I'm sorry for being the guy that always asks these questions, but if we move this into critical infrastructure and what that means is that places an e-felony, in many of the examples that we've talked about, the value of the damage is actually much greater than that, and I think it's not your intention, but I think we could actually reduce a penalty on these bad actors if we're not careful. I think, if you destroy a $100,000 combine, you're going to be way worse off than if we charge you under critical infrastructure. So I want to make sure that we don't actually get ourselves in a posture where we're being softer on these criminals than we otherwise should be. And actually, we were talking about this kind of offline up here, but and maybe it's a question for legal, but if they have the option, I don't know if we could hear this from legal, but I guess the DA would have the choice as to which one they decided to prosecute under to move forward on.
We'll go out of service to hear from legal. I'm sorry, out of session. Hey, my brain is out of service at times, Out of session, I'm sorry.
Michelle Fogarty, Office of Legal Services. Under the Critical Infrastructure Vandalism Statute, in subsection D, it states that a violation of this section is punished as a theft and graded in accordance with theft. So it's a minimum punishment of a Class E felony. If the value of the vandalism is more, then it could be higher. So yeah, the punishment for a violation of this section can in no event be less than a Class E felony, but it can be higher based upon the value of what was vandalized. But to answer your question, yeah, prosecutors would have the discretion to charge however they see fit, under whichever statute they find most appropriate.
You have any other questions for legal?
No, sir. Thank you very much for the indulgence.
We're back in session.
Thank you, Mr. Sponsor. That was a great explanation. I think it's a good bill.
Any other questions for our sponsor now that we're back in service here? We're back in service. All right, that's right. Any objection to the question? Seeing none, we're now voting on House Bill 1145 to send to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. Move on to full criminal. Thank you.
Mr. Chairman and committee.
Members, we are going to skip ahead and take up item number 26 on our calendar. Item number 26, House Bill 17. Motion. Representative Lamar, we have a motion and a second. Representative, you're recognized.
Good morning, committee. How are y'all doing? This bill is a bill I've been working on for the last 3 years closely with you all. It is my human trafficking self-defense bill. What this bill does, it allows victims of human trafficking, if they use force that causes seriously body harm or death, and they reasonably believe their life was in danger, they can claim self-defense through testimony only in the criminal courtroom. We passed this bill last year on the House floor, and I'm bringing it back to get it passed again, and hopefully we can get it through the Senate. I'm open for any questions, Mr. Chairman.
Thank you, Madam Sponsor. Any questions for our sponsor? Chairman Curcio.
Thank you, Mr. Chairman. I'll be brief. I just want to thank you again. I know you've been around the barn on this. We had a summer study. It's an excellent bill, and I hope you don't get slowed down this time. So congratulations.
Thank you, Mr. Chairman. I appreciate your help.
Any question has been called. Without objection, we're now voting on House Bill 17. All those in favor say aye. Aye. Those opposed, no. The ayes have it. You move on to full criminal. Thank you. Members, we will go back to item number 11, House Bill 924 by Chairman Wright. It has been rolled 2 weeks. Moving on to item number 12, House Bill 545 by Chairman Dixie has been rolled 1 week. Item number 13, House Bill 563 by Chairman Dixie has been rolled 1 week. Item number 14, House Bill 994 by Leader Love has been rolled 1 week. We are now on item number 16, House Bill 430 by Leader Lamberth. Motion and second, you're recognized.
Thank you, Mr. Chairman and members of the committee. This bill came to me from several members of a judicial community that had a case that occurred where a woman facilitated the rape of her own child by literally giving her child to a sex offender for a period of months over a summer. Knew exactly what was going on, not only did nothing to prevent it from occurring, but actively facilitated that horrendous crime against this child. When convicted of facilitation of rape of a child, that woman, I will not call her a mother, is eligible for parole at 30%. And the rapist is not, and there is no reason that I think in the criminal code that the person that facilitated that rape should be eligible for parole. We can't affect the crime that already happened. I mean, there's nothing we can go back in time and change that sentence, but we can keep it from ever happening again. This would also put a person of that type on the sex offender registry, again, going forward. It will not affect the case, unfortunately, that I just described. This is very, very rare, as you can see from the fiscal note, but I think a needed update in the criminal code.
Thank you, sponsor. Are there any questions for the sponsor? Seeing none, any objection to calling the question? Question's been called. We're now voting on House Bill 430 to go on to full criminal. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. Moves on to full committee. Thank you.
Thank you, Mr. Chairman, members of the committee.
Item number 17 on the calendar, House Bill 478 by Leader Lambert.
Second.
Have a motion and second. Leader, you're recognized.
Thank you, Mr. Chairman and members of the committee. This bill merely goes back into the Juvenile Justice Reform Act we had from several years ago. It allows for some flexibility by our local juvenile court judges. There are a couple different bills on this year. This one is a much more minor tweak to the code. I think Chairman Curcio has a much larger attempt at this. This will add things like aggravated burglary back into the detention ability of a judge to have the discretion to allow that child to stay in the juvenile system instead of being transferred over to adult court. Unfortunately, when we passed the Juvenile Justice Reform Act, we've seen that many of these children are being transferred to adult court because we've taken away the judge's ability to have some detention and probation there in the juvenile court system. The preference and I think the best policy would be for that child to be monitored under the juvenile court system unless absolutely necessary to transfer them to adult court. That's basically the bill.
Thank you for the explanation. Any questions for our sponsor? Question has been called. Without objection, we'll be voting now on House Bill 478. Send it to full criminal. All those in favor say aye.
Aye.
Those opposed, no. Ayes prevail. You move on to full. Thank you. Next item on our calendar here, number 18, House Bill 606 by Leader Lambert.
Second.
Have a motion and second. Leader, you're recognized.
Thank you, Mr. Chairman. There's a gentleman that I have known for years and I consider a dear friend. His name is Norris Skelly. Norris has probably emailed all of you. Norris, for reasons that he can explain, is very passionate about reducing the number of victims that we have by DUIs via intoxication. He's a very good man, and he, again, a dear friend of mine and many of y'all's. He works with Mothers Against Drunk Driving as a volunteer advocate for their issues. Norris has brought to my attention many different times that if you kill someone with a gun, then you obviously are not eligible for parole till deep into your sentence. But if you use a car and you are intoxicated and you kill someone, they're just as dead as the other crime, but you are eligible for parole at 30%. This is an issue that is extremely important. I will not spend an enormous amount of time on the committee today unless there are a lot of questions, but it's a very simple bill, but it is extremely important because I have sat in parole hearings with many, many families and begged the parole board to leave the person in that killed their loved one. And the only reason we were there is because we as the legislature had allowed those murderers to be eligible for parole at 30%. Most of you on this committee know this, but in case you do not, the reason this issue is extremely important to my family is because my Aunt Lola was killed by a drunk driver when she was out on a date at 15 years old. She babysat me as a child. I will never, ever, ever get to know her. She will never have kids. She will never have graduated high school because of a drunk driver. Because some guys were headed to Mardi Gras and decided to start drinking early, as if that had any importance in this world whatsoever compared to her life. So I grew up in a family that knows what it's like to be shattered for generations because somebody has stolen from you because of somebody else's selfish decision to get intoxicated and get behind the wheel of a 3,000-pound bullet hurtling down the road. I ask for your support for this bill, for families like the Skelly family, families like ours, and for every family that has to beg the parole board to keep a killer behind bars.
Thank you, Leader. Are there any questions for the sponsor? Seeing none, question has been called. Without objection, we're now voting on House Bill 606 to go to full criminal. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. Moves on to full.
Thank you, members. Thank you, Chairman. And again, to my parents, I don't share that story often, but thank y'all for listening to my story this morning.
Thank you. Next item on the calendar, number 19, House Bill 534 by Chairman Howell. Motion and second, you're recognized.
Thank you, Mr. Chairman. This bill came to me from the threat assessment team on school violence in Bradley County. This team was appointed, one of the first actions taken by our Sheriff Steve Lawson, 2 years ago. And he put together this team, and it's very, very active, and it focuses on school violence. It's interesting that multiple states have enacted legislation that specifically addresses school violence, and of course, we all want to keep our students and our schools safe. And the purpose of this bill is simply to create the ability for the courts to hold a student who makes a credible threat of school violence against the school and his or her classmates. It creates the ability for the court to hold this person over for psychological evaluation so that the court can determine if the student is a credible threat to himself as well as to others. Currently, there is no code, I'm told by my DA, under which they can actually hold this child. And so that is the reason for this bill, and I would ask for a positive vote.
Thank you to the sponsor. Any questions for our sponsor? Question has been called. Without objection, we're now voting on House Bill 534 to send to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal. Thank you. Members, we're going to go out of order here and skip down to item number 24 on your calendar. Item number 24 by Chairman Farmer, House Bill 1128. A motion and a second. Chairman, you recognize.
Thank you, Mr. Chairman and committee members. And what this is, back in 2019, Secretary of State's office came to me and asked me to carry what was named the Safe at Home bill. And what it does is provides folks that have been victims of domestic violence, stalking, human trafficking, and sexual offenses to have their addresses basically masked. So that way the folks that have done that to them and caused all that pain and suffering can't find them. So this program has been working so well that now what we're doing is we're coming back and we're asking to expand that to not only apply to their spouses and themselves, but also to maybe their an elderly parent, a new spouse, a child, a caregiver, or something like that resides with them as well, so they can't be tracked that way. So that's what this bill does, and that's what I'm asking this committee to pass.
Thank you for the explanation. Any questions for our sponsor? Question has been called. Without objection, we're voting on House Bill 1128 to go on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full. Thank you. Members, we're back on House Bill number 216, which is item number 20 on your calendar. Motion in a second. Chairman Curcio, there is an amendment to this, 004215. Do you wish to proceed with that amendment?
Yes, sir. Amendment coded 4215 does make the bill.
Okay. We'll get a motion and a second on that amendment.
Thank you, members. Thank you, committee. I will try to be brief. I know we're fixed for time, but this is a large enough change that I think it warrants some explanation. So, a lot of us I know haven't been kicking around the General Assembly for as long as some of the others. Leader Lamberth mentioned earlier that we passed the JJRA, the Juvenile Justice Reform Act of 2018, a couple of years ago, and actually at that time he was the chairman of this committee and I was his vice chair, and so the two of us, along with Chairman Zachary, at that time, worked really hard with the Haslam administration to get the JJRA across the finish line. So I want to say that I'm a friend and I'm an ardent supporter of the JJRA. I believed in 2018 before the lights went out, and I believe now that the JJRA generally moved our state in the right direction towards reforming Tennessee's juvenile justice system. However, I simultaneously believe that not all theories we implemented in the JJRA work in practice. I discovered last year that I'm not alone in this belief. The Tennessee Council of Juvenile and Family Court Judges, our state's boots on the ground dealing with the application of the JJRA on a day-to-day basis, they have discovered that there are some areas of the law that could also use some reform. So most of their suggestions relate to presumptive lengths of stay and disposition, options such as probation, DCS custody, and detention. So in other words, if you want to think about this, how long can we keep a child and why? The JJRA removed detention as a disposition option and imposed a 6-month presumptive cap on both probation and DCS commitments. And while those of us here in the General Assembly amended that statute 2 years ago to allow for a 48-hour hold period of detention while the child's not in school, other juveniles are far too often sitting in custody awaiting placement, only to have the clock run out on the judge's ability to hold them, and then they are released having not received the services they needed in the first place. This has inadvertently created a no man's land of not really detention and not really placement and certainly no treatment, while children become further victims of a system that has failed too many already. We have to look no further than Governor Bill Lee's Criminal Justice Implementation Task Force to find experts, our own experts, by the way, saying that if you take a low-level offender and give them a high level of supervision, you are creating the chances that that individual has of having a safe, you're reducing the chances that they'll have a successful reentry. While the 6-month limit was designed to prevent, it has actually exacerbated the problem it was trying to prevent. The child is held for placement, the clock runs out before a bed can be found, and then we send them home worse than we found them. What I'm proposing today is to remove these limitations on judicial discretion, allowing judges to require dispositional options as long as they are in the best interest of the child. Many of you will note that our state has held firm to the use of, quote, best interest of the child standard in every other section of juvenile and family law, so Tennessee should treat juvenile justice no differently. Moreover, later this year, I suspect we'll have a great many bills presented to this committee designed to preserve or restore judicial discretion where it is under fire or has been restricted. This issue should be no different. Let's grant our judges the discretion they need and make sure every action that we take is in the best interest of that child. So sorry for the lengthy explanation, but it's such a large change that I wanted to make sure that I got those statements on the record. Thank you, Mr. Chairman.
Thank you. Any questions to the sponsor on this amendment? Representative Beck?
Thank you, Mr. Chairman, and I applaud Chairman Curcio for his efforts. I guess the main thrust of this, as I read it and hear your explanation, is removing the hold requirements. How does that increase state expenditures almost $7 million?
Thank you for the question. So again, the main emphasis for the bill is to do things that are in the best interest of the child. But since we are removing that 6-month cap, I think the theory is that some of these kids will be retained longer than that. So by removing the cap, you are going to lengthen some folks' stay. Other folks will have a shorter stay. But I think that's where the cost comes in.
Very good. Thank you.
Thank you, sir.
Any other questions? Leader Lambert.
Thank you, Mr. Chairman. I would ask that Fiscal Review take a deeper look at this because, again, this is just from anecdotal evidence from seeing what happens in courtrooms, like actually what is occurring with these children and the chairman's trying to resolve. I don't know what type of savings we will have on the children that were not transferred to adult court. I mean, there are children because of this bill that will not go to prison, that will not be on state probation, we will not have that expense as taxpayers of Tennessee, and that's the shift. So while it will cost the juvenile court system more, it may save money. So I don't know if that analysis has been made, Mr. Chairman, but I would certainly like to see it.
Thank you. Any other questions for the sponsor, Representative Hardaway?
Thank you, Mr. Chairman. On the amendment rewrites the bill, in the caption text, it cites that it removes the requirement that a court review the case of each delinquent child placed in the department's custody at least every 6 months. Is that in your bill? Or does the amendment take that out?
Thank you, Mr. Chairman. I'm sorry. Your question is, can you restate the question?
Is there a requirement for the court to review the case of the delinquent child at a minimum of every 6 months?
Oh, thank you. I think that bit is removed because we are removing the 6-month cap. So I think at that 6-month cap would trigger the review. So since we're removing that, that's why it states that. But that's not really the intent of the bill. Again, we're just saying let's remove the cap, but allow the judge to act in the best interest of the child, whether they need to keep them 2 hours, 2 weeks, or 2 months.
Right. So without the cap, what is the mandatory review requirement? Review by the court?
I don't think I know the answer to that question.
Okay, I'll seek to get that answer from you later now.
That'd be fine. Again, it'll be after they complete their sentence. So because there is now a 6-month cap, that's when the sentence would be completed because there is a cap. So that's when they would review it. When we remove the cap, again, whether they keep them 2 hours, 2 weeks, or 2 months, whatever the end of the sentence is, that's when the judge would review it. So hopefully that answers it. But that's why it says that, is because when the 6-month cap goes away, so does that hard stop of a 6-month review. Under this new proposed arrangement, the case would get reviewed whenever the sentence was over, even if it was after 2 weeks.
So does your bill as amended allow for an indefinite period?
It allows for whatever is in the best interest of the child.
Okay. So I'll get with you later, but it would seem that we need to build in some type of periodic review for those circumstances. Thank you, Mr. Chairman. Thank you, sponsor.
Thank you. Are there any other questions for the sponsor on this amendment? Seeing none, any objection to calling the question? Seeing none, we're now voting to add amendment number 004215 on the House Bill 216. All those in favor say aye. Aye. Those opposed, no. The ayes have it. We are now on House Bill 216 as amended.
Thank you, Mr. Chairman. Thank you, members. I renew my motion.
Question has been called. Any objection? Seeing none, we're now voting on House Bill 216 as amended. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. Moves on to full criminal. Thank you. Members, we are out of time for today. 11 o'clock is our stop time. I apologize for those that have been waiting anxiously all morning, but you can be with us again next week at 9 a.m. as we will reconvene on our calendar next week at 9 a.m. Is there any unfinished business before this committee? Chairman Howe, you recognized.
Mr. Chairman, I would make a motion that this committee reconsider its actions on, I can't remember the House bill. Representative Castleton's bill.
House Bill 373, is that what you referenced?
I believe that's it, House Bill 373.
We have a motion and a second. Okay, we will be taking a vote to reconsider our actions. Unless there's an objection.
An objection.
Now we're voting on previous question. Okay, you're recognized.
Thank you, Mr. Chairman. I was not objecting to the previous question or voting. I was merely going to state we had already handled this. Obviously any member can make this motion at any time, but the bill had been debated and voted upon, and I think we have another bill that's on a very similar topic. So that was the only point I was going to make on it.
Curcio.
Thank you, Mr. Chairman. Parliamentary inquiry, the position we find ourselves in is that a member has made a motion to reconsider the actions. It's been seconded. My question is, when we go to vote, does it take does it take a majority of members present or 2/3 majority of the committee?
It's a majority of those, from what I've been told, present and voting.
A majority present and voting. Thank you very much, sir.
Representative Griffey.
Thank you, Mr. Chairman. And if we approve the motion to reconsider, that will just bring it back to the committee again for further discussion, not an up or down approval. Is that correct?
Okay. Voting to reconsider does not take action on the bill. It just brings it back before the committee. The sponsor will still have to be here to present it, so it will not be, there will be no final disposition on the bill. So we're now voting on reconsidering, bringing this bill 373 back to committee. All those in favor say aye. Aye. Those opposed? No. The ayes prevail. It will be brought back before this committee. Members, all bills that were left on the calendar for today will be rolled until next week's calendar, next Wednesday. Without objection, we will be adjourned for the day.